attorney that had a long journey going through the courts dealing with a severe parental alienation case. Ryan Blue is a licensed attorney in state and federal courts in Arkansas, as well as the Eighth Circuit um, Court of Appeals and the United States Supreme Court. He received his JD from the University of Arkansas in Little Rock and has also clerked in Arkansas Attorney General's office. He served on the board of directors for the court-appointed special advocates, also known as CASA, of Northwest Arkansas. He has had over a quarter of a century of legal experiences protecting the rights of the clients inside the courtroom. He has a brilliant understanding of parental alienation when it comes to the court proceedings and trials for fighting for these families. He's an adjunct faculty member at Northwest Arkansas Community College, teaching courses on civil pretrial and litigation in the parental paralegal department. I'm sorry. So without further ado, let's hear from Ryan.
Okay, well, thank you so much for having me, everybody. My name is Ryan Blue, and I'm a licensed attorney in the state of Arkansas, and I have been for 25 years, and I've done child custody, child abuse cases for 14 of those years, and so quite a bit of experience here. And today I'm talking about how to litigate parental alienation cases. And you've had a lot of speakers today talk about alienation, so I'm not going to get into the details of what that means necessarily. But I will talk about what it looks like in the courtroom. And I know that many of you may not be attorneys, and you might say, well, how does this apply to me? But I think that what you will learn, hopefully today, is that you will probably encounter the courtroom at some point, either as a witness, or if you're a counselor, your client will be a witness. And so I think there's a lot to be learned from seeing, how these alienation cases are litigated in the courtroom. So let's go ahead and get started. Let's just jump into it. I'll try to catch us back up on time here. But we're going to talk about three main points today. They're kind of the pre-litigation stage, kind of what you do before you even file the lawsuit. Secondly, the discovery phase of the litigation. And third, the litigation phase, what it looks like in the actual courtroom. So when we talk about the pre-litigation phase, before you even file a suit, you want to, number one, educate yourself on parental alienation. What is it? What it is? And that's kind of, you guys are the experts in the field. That's kind of what this symposium is all about. So I'm gonna skip over that. But just I do want to make three kind of main points about the pre-litigation stage. We're going to talk about educating yourself on parental alienation, asking for documentation, and then what the alienator looks like. And I'll put a little picture of an alien there to represent the alienator. Play on words, but also a lot of times what an alienator does is very foreign to us and doesn't really make a whole lot of sense. But first, educate yourself on parental alienation. That's what you guys are doing today, and you're the experts. Number two, asking for the documentation. So before I even file a lawsuit, I want to see all the documents relevant in the case. I want to see the medical records. If there's been a diagnosis of anxiety or depression, for example, I want to see those. When was it diagnosed, by who, and what did they say? If Department of Human Services or Child Protective Services has been involved, then I want to see those records. I want to know what they found or what they didn't find, and who they talked to, and what they think's going on. I want to know what the counselors say. If there's counselors involved, I want to know what they say. Whether I get their reports or if I call them on the phone, I want their opinion on what they think's going on, because that's going to be important. That'll be kind of like the last thing that we end with litigation. And then finally, I want to read the communication between the parents, text messages, emails. If they use a co-parenting app, I want to see their messages, probably like for the previous year. Because what I can do then is I can kind of say, the judge is a neutral third party who reads these. This is how they're going to come across. For example, you might have a client that says, oh, well, the other parent is being very mean in the way that they talk. I can read the messages and go, yeah, but you're being a little passive aggressive in the way that you're talking as well. So there's been some times where the messages have been good. Sometimes the text messages I really don't want the judge seeing what my client said because they're just as bad. So ask for the documentation. And then also we're going to look at kind of what the alienator is actually doing. Now, again, we're still in the pre-litigation stage. I'm asking my client what they're doing. I'm looking at the records. What is our evidence of alienation here? And it can be overtly or covert, right? It can be obvious or it can be subtle. Overtly, sometimes the alienator will just flat out lie. Just flat out lie. They'll say, oh, well, the child gets so anxious before going on visitation and they can't eat and they can't sleep. And when they get back, they're just a behavioral mess and they cry all the time. And, you talk to the child and the child's like, nah, visits are fine. I like going to the other parent's house. They're fine. So they may just flat out lie to you about things, or they may exaggerate. They might, take them, make a mountain out of a molehill. They might say, oh, well, the parent just has canceled the last 2 visitations. How dare they? Okay, well, one was a business trip and when the child was sick. So there's some legitimate reasons there. Sometimes you have to look and see what the alienator is doing, because sometimes they might be doing the exact thing that they're accusing the other side of doing. But most of the time it happens a lot more covertly, a lot more subtle, and that's what makes litigating parental alienation cases so difficult. And I'll give you some examples, and you tell me what you think these rise to the level of alienation or not, or if something else you want to know more information. But if the child gets ready to go on visitation and the parent says, I'm going to miss you so much while you're gone. Let's just say they're going to be gone a week. I'm going to miss you so much while you're gone. Is that alienation? Maybe just by itself, maybe not. Maybe that's an honest statement. Your dog Fluffy is going to miss you so much while you're gone. Is that alienation? I don't know. Maybe. If they just say it the one time, maybe not. If they say it every single day to the child while they're on visitation, then maybe that's getting a little problematic, right? If they make statements like, if the child's on visitation with a parent and they say, are you safe? I sure hope you're safe. Is that evidence of alienation? Well, what does that do in the mind of the child? The mind of the child is, well, I don't know, is the reason why I shouldn't be safe? They start to wonder, and it could start to affect their time with the other parent. If they say, well, is the other parent, are they being mean to you? Are they being nice? Well, I don't know. The child starts to think, well, I don't know, are they being mean? Maybe they start to be a little overcritical. Maybe they start to look for things that they should think that are mean just because the parent has suggested it. So again, maybe just one comment in and of itself may not be alienation. If they're said over and over and over, it might start rise to the level where we've got alienation going on. You guys are the experts on alienation, but from my experience as a litigator, I kind of feel like there's 2 main motivations behind a parent who alienates. One is they've got their own mental health issues going on. Mostly they have probably an anxiety that they're projecting onto the child. Or secondly, they have extreme anger toward the other parent that completely clouds their judgment. And they will do anything to get even or get back at the other parent, even if it means using their child as a pawn. Their judgment is completely clouded because of their anger. Now, again, there might be many other reasons. I'm just saying from my experience as a litigator, those kind of seem to be the 2 most prevalent reasons why parents would work to alienate one parent from the other. So that's the pre-litigation stage. Let's move into the discovery phase. I'll spend just a minute or 2 on this. The discovery phase is just where you get to discover what information the other side has. You got to turn over the documents if they're asked for. Several different ways you can do this. You can ask for documentation, give me the medical records, give me the text messages, whatever. You can send over written questions. Please tell me why you took the child out of the state on June 22nd and didn't tell the other parent. You can ask oral questions in the form of a deposition. You get them in the room and you ask them questions under oath. So now they're bound by their answers and they can't vary from that at trial. And you just ask them questions. Why did you do this? What day did this happen? What was your reason for sending that text message? My strategy when I'm taking depositions of an alienator is I like to kind of play dumb and let them do most of the talking, because the more I let them do the talking, the more they're going to talk themselves into a lie. And I will catch it at some point, either by their own statements or by evidence I have that they may or may not know about yet. So I will play dumb. I'll say, well, tell me what happened on June 22nd. Well, where were you? Where was the child? Well, what happened? Why did you do that? Well, why was that important to you? I'm just asking probing questions just to get them to tell me what was going on from their perspective, what was going on in their mind. And if they want to start giving excuses and if they want to start bashing the other parent, I just let them talk. Again, some point I'm going to catch them in a lie, or I'm going to catch them saying something that I know is not true, which I'm going to use later against them in court. So that's a very quick overview of the discovery process. And with the time I have left, I want to talk about the actual litigation process. So now we are into the courtroom. Parental alienation is probably one of the most difficult things to prove when it comes to child custody and child visitation, because it can be so subtle and it can be so easily explained away. The master alienators are the master manipulators. They can give you the best excuses, and at first glance, it actually sounds legitimate. They will say, oh, well, this happened because of this reason. You think about that and you go, oh, okay, that kind of makes sense. But then you start probing and getting down underneath it and you go, oh, wait a minute, hold on. That does not make sense. That's not what happened. But when you get into litigating parental alienation cases, it's really no different than any other case. You're telling a story. You're telling the court the story of what's going on. If you think back to your high school English classes, a good story is what? Character, conflict, climax, conclusions. Everybody remember that graph from English and composition? Character, conflict, climax, conclusion. And that's the same story you're going to tell the judge. You're going to introduce the characters and say, here's mom, here's dad, here's the kid, here's where they live, here's where they go to school, here's what the divorce decree said, here's the custodial arrangement. And then you move into the conflict. Judge, here's what's going on. Here's the problem that we're experiencing. It's parental alienation. And then the rising action is going to be all those different examples that you have of parental alienation, culminating with the climax in that, Judge, this is the impetus that brought us to this litigation because this happened and we cannot risk this happening again. I had a case one time where a child took too many pills and attempted suicide. Now, whether it was legitimate or just attention seeking, I'm not sure, but it was pretty serious enough that they ended up in the ER. Mom's perspective was the child had anxiety about going to dad's house because dad was mean. Others said, no, mom has extreme anxiety and extreme anger toward dad, and she's projecting that onto the child. So that's why the child's experiencing this. So the climax is, Judge, we have a child who attempted suicide. We cannot risk that happening again. And so the conclusion is, what do you want the judge to do? Well, Judge, I want you to take that child out of that parent's house, move them to dad's house, because if they attempt that again and they're successful, then that's dire consequences of which we cannot come back from. Okay, so it's just no more than telling a story. So what are some effective techniques that you can use against an alienator in court? Again, the master alienator is the master manipulator. If you don't know what you're doing, they're going to be one step ahead of you. They're going to have the best excuses and the best explanations, and you've got to be 1 step, 2, 3 steps ahead of them and know where you're going. So a couple of tricks that I've learned over the years in dealing with alienators is a technique that I learned from one of my absolute favorite movies of all time, A Few Good Men. I'm sure you probably remember that movie from the early 90s. Tom Cruise here. And the scene that we remember the most is, I want the truth, you can't handle the truth. That's the famous scene that everybody remembers. But actually, the most important part of the movie is the line of questioning leading up to that statement, I want the truth, you can't handle the truth. And if you watch the movie closely, here's what he did. And it's a very effective strategy. You take them down this line of questioning, you get them to admit to A. You take them down this line of questioning, you get them to admit to B. And then you show why A and B both can't be true at the same time. And that's the gotcha question. So in A Few Good Men, the question was, is, Santiago's in danger, correct? Yes. But you gave an order that he wasn't to be touched, correct? Yes. And your orders are always followed, correct. The men under your command do not disobey your orders, correct. Okay, you ordered he was not to be touched, correct. A. Now, Santiago was set to be transferred the next morning at 0600, correct? Yes. You signed the transfer order, correct. And he was leaving on the plane the next morning, correct. Then so you get him to commit to B. Now here's the gotcha. If you gave the order he wasn't to be touched, why did he need to be transferred? Because he wasn't in danger. If he wasn't to be touched, he was not in danger. So why did he need to be transferred? And that's the question that rattles Jack Nicholson's character. And that's where Tom Cruise unleashes on him and says, you order the code red, you doctor the logbooks, because he boxed him into that corner that there was no way he could get out of it because he just realized he just completely contradicted himself. Real life example had a case where the judge gave an order from the bench that the parent was to immediately start individual counseling. Well, it took us about a month of arguing over the wording of the order before we actually got the written order entered. And the parent, during that time, did just not do the parenting. So I filed contempt on him, brought him back into court, and said, why did you not immediately start counseling? And they said, well, I don't have to do that until the judge enters the written order. I said, okay. So when the judge said it to you from the bench in person, you didn't feel like you had an obligation to follow it at that time. No. I only had to do it once the judge entered the written order, which was about a month later. Okay. So I went to a different provision. I said, but wait a minute. The judge said this from the bench, but you started to do that immediately, didn't you? Well, yes, I did. Okay. So now I've got them. This portion over here you did immediately, even though it wasn't written, but the parenting classes or the counseling, or you didn't do because the order wasn't written. Why the inconsistency? Okay. So that was kind of one of those gotcha questions that you try to box them in to where there's really no good answer. Okay. A and B both can't be true at the same time. Okay. But you've got to think that, you've got to plan that ahead to lead them into that trap. Okay. That's one effective tool of questioning. Another effective tool of questioning is to turn the question back around on them and ask them, if the other parent did the same thing, how would it make them feel? Okay. So if a parent say they took the child to the doctor and they had him diagnosed with anxiety and depression and got him on medication, but then never told the other parent, you just simply ask the question, how would you feel if the other parent took the child to the doctor, received a diagnosis of anxiety and depression, got him on medication, but then never told you? Okay. The only good answer to that is, I would not be happy about that. I would not want that parent to do that to me. That's the only right answer. And if they don't say that, then it makes them look bad. If they do say that, it makes them look bad. Because there's no really other legitimate answer. Now, they're not going to flat out give you that answer. And so that's why you got to keep hammering it until you get them to actually give an answer to the question, because they will try to explain away, give excuses all day long. But you can't let them do that. Okay, so that's two effective techniques. A third effective technique is not just getting them to say the why behind what they did, but getting them to turn and tell the judge why they did what they did. So if you ask them a question and they said, well, I did this, rather than me saying, well, why did you do that? Because they'll lie to me all day long. I simply say, would you turn and face the judge and tell the judge why it is you said that to the other parent? Why you sent the message to the other parent calling them a blankety blank blank and you want them to go die in a hole? Tell the judge why you said that. Now, for whatever reason, that rattles them and they think twice about lying when they have to face the judge. For whatever reason, if they're not looking at the judge and looking at me, they'll explain it away or lie all day long. But if I get them to look the judge in the eye, it rattles them a little bit. And they have a harder time coming up with excuses or lies if they're looking the judge directly in the face. Three reasons. The fourth technique is don't let them get away with explaining things away with excuses or deflecting. Sometimes they will try to dodge that question and be evasive, and you just have to keep coming back to it over and over and over. And if they make me mad enough, I'll be a little patronizing. I'll just let them ramble, and I'll just stop and go, "Did you understand my question?" Or I'll say, "Would you like me to repeat the question?" Or I might say, "Do you feel like you actually answered that question?" Um, it's just kind of a little somewhat patronizing effect on them to kind of make them look stupid. Like, you really didn't answer that question, and I'm not going to let you get away with it. Or I'll say, would you like me to repeat it? I'd be happy to repeat it for you. And I just keep coming back to that over and over. If they still don't answer it, I'll just say, let me try again. Let me try the question one more time. And I'll just repeat the question. If they still don't answer it, I'll say, did you understand it? Do I need to reword it? And then sometimes I'll just say, Judge, we actually instruct them to actually answer the question because they're not answering the question. Because an alienator they will deflect, they will be evasive because they know they've gotten caught and they do not want to answer that question, and they will try to blame everybody else under the sun. The last point, as I wrap up here, is the use of counselors in litigation. Counselors, especially the kids' counselor, is probably the most important witness next to the alienator themselves. And they're important because they can come in and give their opinion. And here's what you want them to say. Here's the problem. Here's the solution. So the counselor comes in and says, Judge, we've got parental alienation happening in this case, and here's why, A, B, and C. And here's, Judge, my opinion, what we should do. We should limit the time with that alienating parent, move the kid, out of their custody, restrict their visits, and then put that parent in some sort of, co-parenting counseling or whatever their opinion is. And the reason that they're one of the most effective is that they're probably one of the only people in the courtroom that can repeat what the child said. Most rules of evidence, hearsay is you can't repeat what somebody else outside of court said. And so either you got to call the child as a witness, which you probably don't want to do. You get it in through the counselor. And the reason the counselor can do that is they're giving their expert opinion, and they're allowed to state the facts that support their opinion. So they can say, Judge, I think we have alienation going on here because A, the child told me this, and the child told me this, and the child told me X, Y, and Z. And I looked at other documentation, and I've spoken with parents, and I believe those statements are true, and therefore I think we have alienation happening in this case. So they're one of the few people that can get in statements from the child without having to actually call the child as a witness. So I am out of time. I sped up a little bit to make sure we're back on our schedule. But if we've got time for a couple of questions, I'd be happy to answer them. Otherwise, I think you guys are ready to move on to your next presentation. Thank you so much for the opportunity to present to you today. I hope that was helpful to you. I hope you learned a few things that you can implement in whatever professional capacity you're involved in parental alienation.
Thank you, Ryan, so much. If we do have a couple of questions, feel free to answer those real quick. We've got a little bit of time.
Sure.
I had a question for you.
Okay.
Thank you so much. First of all, this is very informative. One of the questions that I have is, as a therapist, what do you look, well, me as a therapist, I always struggle with documentation in terms of like the legality part when it comes to lawyers. What do you look for in our documents to make all these cases?
I'm with you. I think a counselor should probably have as little documentation as possible, to be honest, because it might be subpoenaed, it might be forced to turn over. Be careful. Just, I would say anything that you document, there's a possibility it could be turned over to the alienating parent. They might be able to see it. Now, a good attorney will try their best to keep that from being, having to be turned over. But that is a possibility in these kind of cases. So obviously you want to make notes to refresh your memory as to what was talked about. And if the child says anything important, then I think it's good to write that down so that if you're challenged in court and they say, well, that was 6 months ago, how do you remember that? Well, I wrote it in my notes that as soon as the child said it, I wrote it down. That's how I remember it.
When you ask, when the therapist, when you ask for the therapist documents, can the therapist refuse the documents to you, and ask for the judge to like subpoena their records instead? Do you ever get that?
If I'm representing a parent, a lot of times they'll sign a release to let me get the records. Otherwise, the other side will probably try to subpoena them if they want them. I don't really rely a lot on counseling therapist records or reports or even their notes. I just kind of want to see a quick summary of what they think. I met with the child on this day. We discussed difficulties at home, and they expressed anxiety and going to the parent's house, and we discussed coping mechanisms. To me, that's good enough. It's when I get them on the phone and say, okay, now really what was going on? Tell me really what's going on. That's more important to me.
Okay, thank you so much.
All right, we have time for one more question if anybody's got a question.
If you
Mr.
have an,
Blue?
okay,
Go ahead. No, it's okay, Chris. Go ahead.
If you have an agreement to go into a program like Turning Points, the fixed severe parental alienation with the other party from a final interview with the guardian ad litem, and then you write a proposal of such, and the only person that is arguing the fact is the opposing attorney rather than the other parent, how would you address that to overcome that?
As the attorney, how would I address that?
How would I advise my attorney to handle that?
So are you, just forgive me, are you a counselor or a parent, or what's your
I'm
role
a
here?
parent that has
Okay.
a Superior Court case going on now that guardian ad litem found severe parental alienation, recommended Turning Points as a solution. Other parent agreed in the final interview and on multiple other occasions. However, the attorney is advocating for prolonging the case and running up the bill, and that's been public information.
The attorney of the alienating parent?
Yes. Wants to go to trial rather than settle as both parties want to do.
That is a great question.
And the court
First of all, I'd want to know
is
if the other
supporting
parent is just
the continue.
saying that to appease, and behind the scenes, they're really telling the attorney, fight this and keep going. But if the other side really says, look, we just need to bow out of this, the attorney keeps going, they need to fire that attorney and get somebody else, is what they need to do. Otherwise, I think it's up to the attorney of the other parent to step in and go, Judge, here's the documentation saying that both parents are in agreement to this. I don't know why we're not doing it. But ultimately, unfortunately, I'd probably have to put the pressure on that parent who's agreeing, but who's attorney, and say, look, you're either going to get in trouble with the judge or you fire this attorney.
Yeah. Thank you.